very down to earth, and
I think that was the key.
I think it was.
When she talked to us, she wasn't talking down to us. She wasn't talking at us. The Democrats talk at you. The Republicans talk down to you. She was neither. She talked with us.
Yeah.
Good morning. Welcome back to Talking Racine. It's Mr. George Myers, as usual, Mr. Jim Spodek, our producer, and myself, Dr. Ken Jorgen. And we got a question for you this morning. Is the judiciary system in Wisconsin fair and unbiased? We don't really think so. And we got an example of some of the disparities in the way citizens are treated depending upon their affiliations and their background, who they are, etc., etc. This case that we're going to give evidence on here is we're comparing, well, the lockdown, the COVID-19 lockdown, and the Racine Unified School District case that's in the appellate court. And Jim, you got I know you got some strong opinions about this, and you got a pretty good base of knowledge about it, so I'll let you riff here a little bit.
Well, just recently, actually on Friday this past week, the court came back with a decision on the on this particular one was a Madison case where private schools had sued the city of Madison and the health department of Madison, stating that they felt that they infringed on their rights, First Amendment rights, particularly with closing the schools and the private schools particularly. The Supreme Court came back and basically said, we agree with the petitioners. Local health officials do not have the statutory power to close school. It infringes on the petitioner's fundamental right to a free exercise of religion guaranteed under Article 1, Section 18 of the Wisconsin Constitution, which accordingly those portions of the order restricting or prohibiting in-person instruction are unlawful, unenforceable, and therefore vacated.
Hear, hear.
Yeah. So
About time.
Now, what I want to do is go back to the beginning here and kind of do that timeline from Racine, because this also affected Racine because there were lawsuits in Racine, particularly one, Cross Fitness was one early on that said, hey, our businesses is
You're killing us.
Yeah, subject to some of this restrictions that the city of Racine put on businesses. Also, the schools, there's a number of public or private schools in Racine that also sued the city of Racine and the health department on that being closed down. But I kind of want to go back to the beginning. We'll start with the Cross Fitness, and I got some video here. We can kind of
let's share that with the viewers and bring them up to speed a little bit, and we'll refresh our own memories.
Very good.
Developing story out of Racine. A judge has ruled against the city of Racine and their COVID-19 ordinance, calling it vague and unenforceable.
Big win for the business that sued. Fox 6's Angelica Sanchez has a closer look at the 19-page decision that just came down.
A judge has ruled in favor of the couple that took the city of Racine to court.
Both sides, I think, gave good arguments.
The owners of Harbor Park CrossFit in Racine filed a lawsuit challenging the city's original Forward Racine order, a plan meant to reopen the city in phases due to the ongoing pandemic. The owners argued the restrictions were vague and could put them out of business for good.
If I have rules that are constantly changing, it makes it very hard for my members to understand what product they're getting when they walk in this store.
A judge overseeing the case paused the original city order. Within days, the same judge had to also pause a second effort by the city to place a COVID-19 ordinance when the couple amended their lawsuit. At the time, Mayor Corey Mason called the judge's ruling extremely troubling. In a 19-page decision on Wednesday, the judge called the city's ordinance unconstitutionally vague and unenforceable as drafted. However, the judge also says just because the ordinance was found as vague does not mean some portions weren't good public policy. Prior to the decision, the couple told Fox 6 they take the pandemic seriously and other business owners should too.
I think it's all on our due diligence to make sure that we're doing our part to help the city curb this virus.
Now, regardless of Wednesday's decision, either side has an opportunity to appeal the case through the Wisconsin Court of Appeals. Reporting in Racine, Angelica Sanchez, Fox 6 News.
Angelica, thank you. In a statement, Racine's Mayor Corey Mason says in part, this irresponsible decision jeopardizes the city's ability to protect the health and well-being of our residents in the midst of a life-threatening pandemic.
That, of course, was Judge Frederickson, by the way. His name was never mentioned in there, but that was who had ruled. I mean, to me, I've been in and around the courts as a landlord for 50 years now, and I've never heard the Constitution mentioned. And it was just nice to hear that at the circuit court level, saying something was unconstitutional. There's lots of things going unconstitutional at that level, but it's just like the circuit court judges think, no, they can't say that. They can only rule according to what the law is, and not judge the law as being unconstitutional, the law itself.
You know what was interesting is he didn't come out with any condemnatory language or anything like that. He just said that, this is unenforceable. You guys are too vague here. You're too broad. That's not to say that you don't have some good public policy points in here, but you got to do it the right way. You got to do it according to the Constitution. And Corey Mason's response was, he referred to Judge Frederickson as a right-wing activist judge. That kind of language is not helpful. It really isn't.
No.
He should have gone back.
It's helpful to understanding that Corey Mason's a nutcase, but other than
why don't you just go to the judge and say, well, Judge, what is it that you have a problem with, and we'll
why
take
couldn't this
corrective
be
action?
worked out? I mean,
Yeah.
it's in a court. The judge came in and said it's unenforceable. I agree with him. It was sprawling, and he said it was unenforceable. And
we had all kinds of references. When you read through that, you had to, you're reading through it, and there's a link here, and then you read a little more, and another link there.
It was a very good, and we all read it. We had this a show earlier, and we talked about it, and we agreed it was good, and it was on the right to assemble. I mean, you're taking this pandemic, and then you're overstepping and into and really into the Constitution. And we all know the basics of what our founders said about the fear when you give up your rights for fear.
Yeah.
Yeah, and the idea that that you're driving somebody out of business, you're taking away their livelihood, and some of these people, it's more than a livelihood; it's a dream.
Right.
You keep hearing about, I've always wanted to open a restaurant like this, or I always wanted to have this kind of a store, or this type of establishment, and all of a sudden you just rip all that away from them because, you're not safe, or you're not essential,
so at this
or something
point,
like that.
the Frederickson writes the order. It's in place. The city of Racine, at this point, he left it wide open, saying, "Listen, you change a few things. Maybe we can work with this through, and let's." They don't
come up with a good public
Right.
policy, based on the Constitution. What did they do?
Let's go to the video here. We'll take a look.
See what the news
That's called
said
a
they did.
setup.
Order now back in place. The city's COVID-19 order struck down by a Racine County judge on Wednesday. Well, today the Court of Appeals put a stay on that decision. Sharon Bajenda joins us live with an update on an ongoing battle. Sharon.
Mayor Corey Mason said today's Court of Appeals stay will provide Racine some consistency, at least for a period of time.
Mayor Corey Mason says the stay by the Court of Appeals was granted just in time for the 4th of July weekend.
I think people are confused about whether or not they still need to take these precautions or not. And so certainly having the order back in effect certainly allows us to take the precautions that we need.
Judge John Frederickson struck the Safer Racine order down on Wednesday. He said in a written decision the city upholds its full power to still issue new laws to tackle the pandemic, even addressing it during a 2-hour hearing on Tuesday.
I'm not here to make policy. I'm not here to decide what I would like to see done in Racine and with what, who, and how. That's what the Common Council's for.
But the judge did believe some of the wording in the Safer Racine ordinance on mass gatherings could be unconstitutional.
I'm just a court. I can decide whether things are constitutional or not. Court's a little mindful of its severing power.
In today's Court of Appeals stay order, Judge Paul Riley wrote in part, just as capacity limits set for public establishments for fire safety reasons are not unconstitutional, despite limiting the number of people who can assemble in one place, so may capacity restrictions be set for health reasons to control communicable diseases. The Safer Racine order was put in place last week after attempts to put measures in place by the health department were overturned by Judge Frederickson on June 19th.
It'll be several months, I assume, before the Court of Appeals Appeals ultimately adjudicates their final decision on this, although their order today seemed to give pretty clear indication of what they thought about it.
Mayor Mason says Racine has some of the highest number of coronavirus cases per capita in the state, but he'll fight to make sure the city has proper orders in place during the pandemic, as well as to protect the city's rights to pass public health ordinances.
We'll defend that right vigorously. But at the end of the day, there's also an education component that we need, and we really need people to comply with these orders.
Mayor Mason says police enforcement will happen this weekend, but the goal isn't to write tickets, it's to educate and work with the community. Reporting live, Sharon Bajenda, CBS 58
What struck me
News.
as weird. He talked about this getting done just in time for the 4th of July to allow us to take the proper precautions. What does he mean?
You mean shut that dang parade down? We don't want no.
Does it mean
we don't
that
want
people
no
would not
stinking-
be allowed to be cautious if this ordinance wasn't?
Yeah. Well, that's your idea with government. We're going to control. We'll be able to tell you.
We make all the decisions.
Right.
We make the important decisions.
You as an
And,
individual, well, you're second
you
to us.
Fit in. Yeah. Just do what we
Exactly.
say is right. No, that's an attitude.
Okay. So how did they get this done in 48 hours? That's a remarkable.
That's the key.
Yeah.
So Frederickson puts the order. It comes in. They get the appeals to grant a stay on the order within 48 hours. So Wednesday, the order comes down from Frederickson's court. Friday, the appeals court, look, we're going to stay that. And that would,
That's amazing. I waited.
That's good service.
We waited months or a long time for.
Well,
for
even
the appeals decision made
when you're talking about an injunction or a stay, I mean, it can go fairly quick if there's a real public problem or an emergency situation. Yeah. But 48 hours is almost like unheard of. Yeah. Well, what happened, from what we've gathered, is either someone in the city of Racine, attorney, drove to the appeals court and rallied this stay and was put into place.
It's almost like they had inside contacts.
And I read it. They had it all prepared. This is what they were going to do. They were not going to go to the court and say, listen, maybe we can adjust our safe Racine ordinance to so we don't overstep the Constitution.
Right.
That wasn't something they considered. It was automatically, this is what we're doing, and this is how we're getting it through. Again,
Corey Mason had very obvious connections to the appeals court.
Oh, no question.
Through the Neubauers and so you could see where a phone call could go up. Hey, we're bringing something up, because it had to be set up ahead of time. You don't walk in there on a Friday afternoon and all of a sudden get this stuff looked at and signed and sealed and delivered. It had to be some preparatory work. Hey, we're coming up with a piece of paper. Here's what's in the piece of paper. Can you please be ready for it? And of course, if you've got like family members and connections,
they're all drinking buddies. What are you kidding me? What are you kidding me?
Well, I think it's great that we have somebody situated down here that has the power and the connections to get something like this done in such an expedient way. Even if it does trample on the Constitution a little bit, it's nice to know that they have that power.
Yeah. Well, it really is kind of interesting. And when they put this into play, when they made an ordinance out of it, it was a 9-5 vote on the Common Council. So 9 members of that Common Council basically voted to overstep their authority and violate the Constitution.
To act broadly and beyond what would be
and basically violate the Constitution. And they had no problem with that.
It's just a piece of paper.
Yeah.
For crying out loud.
What I don't like is it's more than add just a piece of paper. It's add just a gym thing. It's just some people wanting to do some exercise, and it's just a business. Don't worry about it. There's more important things than these little businesses running around here.
Well, one thing they seem to miss is that nobody was being compelled to go to that gym. It's not like they said, look, if you're a member of that gym, you better show up 3 days a week or 5 days a week or whatever. They had the option of not going.
Well, Doc, you're getting down to the basis the way I think it should be handled.
Oh, God. We're thinking alike?
Yeah, I know. Dottie Bowersox and the council can offer advice, but That's where it's got to stop. In other words, it's up to the owner of the store, the establishment, whether it's a movie house, a bar, or an exercise gym, whatever it is, and their customers to be aware of the situation and make their own decision of whether or not they want to go there and participate. I think that's what you're saying. Which to me is the way it.
Well, and another thing, these people, even if they were going to the gym, they were not doing something that was demonstrably dangerous to their fellow citizens.
No, they were just on their own going,
Well, and because the language, really, the language of the ordinance was, at that time, the order, was, like the judge said, it was vague, it was too broad, and it was unenforceable. That's basically what he said. You can't enforce this, so what's the point?
Right.
Do it right.
So,
yeah. How does that compare?
Now after this, not yet.
Okay.
But the appeals court, grants it a stay. So now,
and the appeals court said what I said. I just want you to know the appeals court did say that the more concern was for the community than for the business. In other words, the business really wasn't that important, wasn't that thing, but whereas the community was.
Well, I think it was a poor order anyway. You talked about a capacity of a building and different things you can set.
Well, that is
and that's not. We're not talking about the right to assemble or freedom of speech or freedom of religion. They were talking about capacity of a building.
That deals with massive amounts of evidence over many decades saying that you need 2 exits and you have to have we have so many people per square foot. It's a very solidly thing, and not saying that this business is okay, like the liquor stores could stay open,
right?
But the non-essential business over here, the gym, that had to close.
Right.
That was the type of stuff that was in this order. That's the type they were
bringing. When you put it like that, it's laughable. It really is laughable.
Well,
liquor stores can stay open, but that gym, it's a dangerous place.
No, and it's non-essential.
It's not essential, but beer is.
So to mix those two was just ludicrous for this judge to bring in the thing about square footage and something that's very definite.
You got 48 hours, George. You're not going to get this. They're not going to go sit and really study on this. But anyway, so what happens after this was on stay? The Racine Dottie Bowersox Health Department closes the schools, closes the private schools in Racine. So what do? They say, listen, we're going to sue. So the private schools go, and now Madison was suing because in Madison they were closing the private schools. Racine now was suing, and they were closed because they were closing the private schools.
And about this time, too, the information was coming up and become clearer and clearer that little kids didn't get it.
Right.
Little kids were not contracting this disease. They weren't spreading the disease.
So this bounces up to the Supreme Court. So they rush it to the Supreme Court. The Supreme Court puts basically an injunction on it, I guess, a temporary injunction that says, now you can stay open. Not in Racine. The city of Racine actually...
So Dottie Bowersox said, screw what the court said, we're closing you anyway.
Matter of fact, I got a quote here. It says, Jim Bender said the Racine leaders who were defying a Wisconsin Supreme Court restraining order on school closures. Bender is the president of School Choice Wisconsin. He is stunned that they are so brazen against a clear order from the Supreme Court, but I guess they don't think they'll pay a legal or political price.
He says they're drunk with power.
Drunk with power.
Well, it's only because the liquor stores were still open.
I mean, you think about this for a minute. So now let's go from the first Frederickson's court, where you had Cross Fitness saying, hey, I think you're overstepping your boundaries on my business, to now the private schools now are questioning the same thing. And they're coming through. Now, when it comes down to what the Supreme Court said, hey, wait a second, you are possibly overstepping your authority. Well, we don't care. We're going to do it anyway.
What about the schools out in the county? This was just city ordinance.
Right. The schools in the county were open.
How did that work out?
They are fine, from what I understand, Doc. Everybody's
they're still alive out there. They're still cooking, still kicking. No, I know, and it's just this attitude that you can just see it in Bowersox, and when you're dealing with him, and Mason too, when he calls the judge some kind of an activist judge, these people, they're drunk with power. They're very impressed with themselves. We just know better than anybody else what needs to be done here.
I want to throw the city attorney in on that pile.
Yeah.
He's the one
carrying all the ordinances.
He's all in this.
Scott Ledney. I don't want to leave him out. But it's just, I mean, It's been obvious all along that these people are just gone way out. You know, they consider themselves like the gods of the city of Racine. They're no longer just bureaucrats and elected people. They're running things, and they know better than anybody else what should be done around here.
Okay, I want to kind of go off on a little different subject here, because now when the Supreme Court came down and basically said, hey, Frederickson, you're right, the private schools of Wisconsin, you're right, and Corey Mason, guess what? You're wrong. You know, you can't overstep, even with a pandemic or a protection that you think you're implying. You can't overstep and you can't violate the Constitution.
And that is the fundamental thing. Doc,
yeah.
you mentioned a little bit. You said mockingly, "It's just a piece of paper." Yeah, that's what they look like. Yeah,
that was a quote of a president we've had.
Yeah, it's our agreement. It's the formation of this country. It's what the country's all about. We are not an ethnic-based country. We're based on the Constitution.
Okay, this is where the comparison that we alluded to at the beginning comes into play. And the comparison is the 48 hours that it took for the appeals court to respond to the city of Racine and its pandemic orders, and the Racine Unified School District case, wherein several citizens have filed suit. Look, we just want to look at ballots in a very limited number of wards. And that's now up in the appeals court, and it's been there for how long?
Oh, no, the appeals court kicked it out, Doc. We're going to the Supreme Court now.
Oh, that's right. Yeah.
What happened?
They completely stepped on it, didn't they?
Yeah, they basically, here's the bottom line of this. And I'm going to read it. It was Section 7.54 of the Wisconsin State Statute, which reads, in all contested election cases, the contesting parties have the right to have the ballots open and to have all errors, the inspections, either in counting or refusing to count any ballot, corrected by the Board of Canvassers or court deciding the contest. So basically, all the petitioners are asking for is to open those ballots in a quorum, and that's all they're asking.
The ones where where questions were identified,
Correct.
You know, where irregularities were seen. I saw them, you saw them, George,
Right.
you were there.
So
and
we
saw
brought
them
them into the circuit court. The circuit court never answered that question. Never addressed Wisconsin Statute 7.54. Basically said, Unified, they did it right. The canvassers did it, even though they were all school teachers, and the administration was involved, and the lawyer was hired by Unified, and it was a complete setup.
Yeah.
Oh, they did it right. That's it. So then it was appealed. Went to the appeals court. I'm going to read some. Instead, the appeals court said, although the law did apply, it is there to give the judge an option. Although the statute authorizes opening the ballots, it does not require that a court do so, is what this is saying. Incredible, this is written. In other words, when the law states that a contesting parties have the right, it actually means no right at all, because the judge gets to decide. So the appeals court never answered this question. They never said, hey, you have the right to look at those ballots. I mean, why all the ballots?
People should really, because you went over real quickly there, and it's easy to miss. The point is, if you have a right to do it, then you have a right to do it.
Absolutely.
Yeah.
But if your right is contingent upon the judge saying okay, then it's really not a right.
Exactly.
And that's what the point you were making there, Jim, is, and that's what we're up against now. Is it says right in there in the law we have the right to do it, but unless the judge says we can do it, well, we can't look at it.
So what the appeals court did here, basically said, well, we don't see anything. It never answered the question. So they basically punted here.
Yeah.
So now, instead of
and it took them a lot more than 48 hours to do it.
Oh, months. So here's the difference. 48 hours, boom, you get a stay in a matter of hours. Here, you don't even get them to look at it.
So what we're complaining about is we're not getting unbiased, equal treatment from the judiciary in some instances. And the Court of Appeals is the instance that we're talking about that's demonstrating our complaint here.
Right.
Now, George, you had something you wanted to cover before we get the heck out of here this morning.
You're talking about with the judges?
Yeah.
Yes. I mentioned earlier on that this is the first time I've heard the Constitution mentioned in circuit court. And I find that amazing thing. And in fact, Judge Fredrickson was on the video. He mentioned once again his ability to look at as a judge his authority, not his ability, but his authority, and to look at things constitutionally. This guy acts in every way like an appellate judge. I think that we should be looking at, somebody should be looking at him getting into that branch of the judiciary. I mean, he's doing great as a circuit judge. Those that have, we know some other cases that have been for him that say it's marvelous to work with someone like that investigates the law that's well and investigates the case that well and applies the law so well. But sometimes, it's great to have the person up a couple levels, because it becomes even more impactful when the lower cases judges are kind of letting things ride, and there's somebody up there that's willing to really take a look at it
to actually work.
And there's a gal that just went in there, Shelley Grogan, who seems to be someone like that, who's willing to look at things that other people are passing up, and it'd be nice to have someone.
Well, it's interesting. I had the opportunity to meet Shelley and talked a little bit, and one of the things she won. Now this was Davis. She ran. That was a sitting appellate judge, and he was beaten by Shelley Grogan by 14 percentage points, which is huge.
Yeah, it's a big.
But also, are you going to say it's never been done before?
That's what
okay, go ahead and say it. Yeah, go ahead and say it.
I don't believe. Now I don't know if this is actual fact, but it's certainly understandable. It's never a sitting appellate judge has never been beaten. In the Second Circuit Court.
Yeah.
Well, they can't say that anymore.
No. But here,
and she won by 14 points.
Yeah, that's
crushed it. Now,
amazing.
what I said was, what did
you do?
How did you do it? And a very nice woman, very down to earth, and
I think that was the key.
I think it was.
When she talked to us, she wasn't talking down to us. She wasn't talking at us. The Democrats talk at you. The Republicans talk down to you. She was neither. She talked with us.
Yeah.
She was
and she
very
said,
sociable.
I drove around like I was an 18-year-old girl. She said, I met everybody, talked to everybody, and told her what I was doing, how I was doing it. She said Davis had $500,000 a war chest to go out there and campaign. I didn't have that kind of money. And, I thought, the next day I was thinking about it. I was thinking, I get it. But that's been done before. You can campaign like crazy. You can drive around and meet everybody, but
you can't meet everybody,
right? But the fact is, you got $500,000. You're pumping those mailboxes with flyers. You're getting endorsements. I mean, you've got the upper hand as the incumbent.
Oh yeah.
And the more I thought about that, I thought, there's a shift here, because I think Davis, and I said this on the show, that Davis came across as this, conservative. Well, when I see some of the rulings, and one being the unified one that he was on, I mean, and I know people don't look that deep into this, the average person, but I think there's a shift there that says, hey, we don't want activist judges. We don't want political machines. We want people that are going to judge with the law, actually use the law. And I think when you see a Fredrickson, that's what you've got.
And then looks at the case too.
Absolutely.
Because this is what we face over at Unified. No one would look at the case.
Yeah.
They just said, they would look at the procedure, and it's Unified. And,
right.
They're lawyers and
great.
Everything's good. There's nothing to see here.
In fact, you brought up a good point about the political. The courts now are becoming
the connections.
Yeah, they've been politicized. I mean, when you can even call somebody a right-wing activist or a left-wing activist, and you're throwing those labels around. And they're really meaningless, but they do have an impact. And if you got $500,000 and you're throwing out all that literature like you were talking about, it starts to embed itself in the public mind. And, some people will probably see Fredrickson and maybe recommend this or remember this. It doesn't apply. I mean, you don't think he's a right-wing activist. I don't.
No.
And we differ politically fairly often. And neither do you see him that way. So, they got to get the politics out of these judicial elections, the political party activism. It's just poisoning the system.
But here's one of the things I want to just say before we close up here. He took on a case that was totally unpopular. You had a pandemic. You had people afraid. You had the city putting an ordinance in, and he said, hey, wait a sec. Stop. What judge in the city would have done that?
No, I know that
There's
was
nobody.
really
I mean,
unique. But he took that up.
The deer slayer Piontek would have let it roll. You know, I mean, this is the kind of stuff that you had to have the guts to say, wait a second here, I'm really going to look at this, and I'm going to look at it with the law and the Constitution. I mean, hell, we were shocked when that happened. I mean, it was shocking.
And you shouldn't be.
Yeah, you shouldn't be, but we were.
That should be the norm.
So when you talk about, they sling these words around, activist judge and all that bullshit, excuse me, but I think this is the kind of stuff that propels you to higher levels, and hopefully he's looking to do something like that.
Yeah. Well, that's it for today, huh?
Yeah, good.
So we hope you guys enjoyed being here. We enjoyed having you. Come back and see us next week. Hopefully things will be better in another 7 days.